I think that was pretty good, actually. I was really impressed when I read it before, and I'm just as impressed when I read it now. That was a good opening. I like this guy a little bit.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
You may recognize the next case because this is an update in the Steve Sands Richard Leibowitz copyright troll case, and this is about calling Richard Leibowitz a copyright troll. So I try to use the term sparingly. A copyright troll to me is like when Right Haven was suing people who didn't own copyrights. They owned like the right to sue, and the court said that doesn't count. You either own copyrights or you don't own copyrights. You have to own the whole bundle of property rights that are copyrights. Then we have Prenda Law, who literally didn't own copyrights, was literally seeding their own BitTorrent activity to try and then track BitTorrent activity and sue people, and was really doing some other nefarious things like trying to get a like example defendant to roll over on the other defendants even though none of them know each other. That's a copyright troll. So when Richard Leibowitz complains that he doesn't like being called a copyright troll, I am a little sympathetic. Let's see how much sympathy you have for him after his memorandum of law in support of his motion for the judge to recuse himself, as in the judge to remove himself from the proceedings and assign a different judge. Let's just jump right in. He starts quoting, according to the U.S. Supreme Court, judicial remarks during the course of a trial that are critical or disapproving of or even hostile to counsel, the parties, or their cases ordinarily do not support a bias or partiality challenge. They may do so if they reveal an opinion that derives from an extrajudicial source, and they will do so if they reveal such a, emphasis added by Leibowitz, a high degree of favoritism or antagonism as to make their fair judgment impossible. And then Leibowitz starts in his words. The term troll, when applied to an actual human being, is never used as a compliment. It is meant to defame, degrade, and stereotype a person as a rotten miscreant or nefarious villain. It is intended to invoke wide-ranging negative connotations that suggest harassment, abusive practices, depraved motivations, and even illegality. Once a person labels another human being as a troll, certain truths become self-evident, the most obvious being that any actions taken by the so-called troll will be perceived through the lens of that negative stereotype, and any judgments rendered will inevitably function to confirm that hostile perception. I think that was pretty good, actually. I was really impressed when I read it before, and I'm just as impressed when I read it now. That was a good opening. I like this guy a little bit. At least he writes well. How about that? Let's put it that way. On September 18th, 2019, the Honorable Judge Louis A. Kaplan entered an order in this action in which he condemned plaintiff's counsel Richard Leibowitz as a, quote, copyright troll, and accused him of filing strike suits designed to extort settlements. The definition of copyright troll is nowhere to be found in Black's legal dictionary, nor in Blackstone's. It is not a legal term of art used in the Copyright Act, nor in any other congressional statute or federal rule. The term copyright troll is nothing more than a pejorative schoolyard epithet that has no place in the judicial lexicon of an Article 3 officer. This is pretty good. Indeed, the original source of the definition of copyright troll as quoted by Judge Kaplan is the Iowa Law Review, see Matthew Sag, Copyright Trolling, an empirical study from the Iowa Law Review of 2015. In that law review article, the author stated that copyright trolls are, quote, more focused on the business of litigation than on selling a product or service or licensing their copyrights to third parties to sell a product or service. A copyright troll plays a numbers game in which it targets hundreds or thousands of defendants, but The Iowa Law Review definition was not used to describe an officer of the court. It was used to describe a party or plaintiff. As such, to the extent that any legal definition of copyright troll exists by virtue of the Iowa Law Review, such definition cannot possibly extend to an officer of the court without rendering the original definition without meaning. Mr. Leibowitz does not own any of the copyrights he litigates. He is not in the business of owning copyrighted works to which he himself made no artistic contribution. Rather, Leibowitz represents the original copyright owner and author of protected works against publishers who have violated that copyright holder's constitutional and statutory rights. And without Mr. Leibowitz, these photographers would have no one to represent them in federal court, and their works would be stolen with impunity. Judge Kaplan believes it is fitting to describe Mr. Leibowitz as a copyright troll, based on nothing more than the high volume of cases filed by Mr. Leibowitz in the last 4 years. Judge Kaplan blames the high volume of infringement cases squarely on Leibowitz, stating, "This deluge of cases is attributable to plaintiff's counsel in this case." But that would be like blaming the DEA for all the drug traffickers it prosecutes, rather than the traffickers themselves. It's not Mr. Leibowitz's fault that the publishing community steals photographs en masse. He is appropriately responding to an epidemic of intellectual property theft, which has pervaded American media companies who have found it more cost-effective to steal photographs than to abide by federal law. To further demonstrate Judge Kaplan's high degree of antagonism against Mr. Leibowitz, Judge Kaplan has consistently described Mr. Leibowitz's meritorious filings as strike suits designed to extort settlements. Federal statutes define extortion as the obtaining of property from another with his consent, but induced by wrongful use of actual or threatened force, violence, fear, or under color of official right. How exactly Mr. Leibowitz has committed the crime of extortion by filing meritorious infringement claims on behalf of copyright holders, as specifically contemplated by the Copyright Act, has never been explained. First, Mr. Leibowitz represents the individuals who actually own the property that is being litigated. Given that Mr. Leibowitz and his clients are not using other people's property to litigate these claims, but are actually using property they own, any claim that Mr. Leibowitz commits extortion by filing meritorious infringement claims cannot be supported under law. Second, to the extent Judge Kaplan has decided that civil litigation involving copyrights of modest value constitute wrongful use of actual or threatened force, plaintiff respectfully refers Judge Kaplan to Section 504 of the Copyright Act, which contemplates that infringement actions seeking no more than $200 may be prosecuted to the full extent of the law through full dress jury trial to final judgment. That is what the people of the United States, through their congressional representatives, have decided. And that's because theft of intellectual property, regardless of the monetary value involved, strikes at the heart of what it means to be both a human being and a U.S. citizen. A human being and a U.S. citizen. After all, the prosecutions accorded to copyright holders are enshrined in the native document itself. See Article 1, Section 8, Clause 8, making it one of the few civil actions that the founders even contemplated. While Judge Kaplan may have a problem with the Copyright Act as written and doesn't believe that meritorious infringement claims of modest value should be litigated, it is not his role as a member of the Article 3 branch to pass judgment on Mr. Leibowitz's so-called business model. It is Judge Kaplan's role as an Article 3 officer to adjudicate the cases in which he is assigned based on the congressional laws as they have been enacted. Steve Sands respectfully submits that Judge Kaplan has abdicated that role by viciously condemning Mr. Leibowitz as a copyright troll and accusing him of filing strike suits designed to extort settlements. Judge Kaplan's persistent commentary on Mr. Leibowitz's so-called business model, coupled with his non-legal use of the highly pejorative terms troll and extort to scandalize an officer of this court, qualify as a high degree of antagonism as to make fair judgment impossible under the standard established by Lightkey versus the United States in the opening statement. Accordingly, in the interests of manifest justice, not just justice, but manifest justice, we want to show this justice, Judge Kaplan should recuse himself from this proceeding and permit another Article 3 judge to preside over a fair and impartial adjudication on the merits. What do you think of that? I think that was a pretty good opening. I have to take a step back because, like, wow, I'm like fawning over that opening a little bit. So, like, I don't want to just agree with him. I mean, maybe Richard Leibowitz is kind of a copyright troll, isn't he? He files actions even though he might not be fully compliant with his Rule 1.1 duty of confidence. An attorney must be confident. No, his Rule 1.1 duty of competence, which competence means some very straightforward things, like he has to basically be a trained lawyer. Okay, great. He shouldn't take cases that he doesn't know how to handle. Okay, well, even if he knows how to handle it, you can still think of a level of incompetence with which it could be handled, even if he knows how. So he has to not only know how to handle it, he has to handle it competently. And he's making a few too many mistakes, as we've been pointing out in our reviews of various judges who have pointed these things out. Again, I'm just the messenger making a YouTube channel. It's Leibowitz who's making the mistakes, and the judges and the opposing parties that are holding him in contempt or sanctions or whatever they're doing to him in these cases. So, like his analogy, maybe he really is a copyright troll. I think that's a matter of opinion, and since it's not a legal term of art, I think it falls squarely in the realm of non-defamatory opinion. Now, that doesn't mean that a judge isn't held to a higher standard, and even a non-defamatory opinion of a judge could still be bias. And we do want fair and impartial judicial proceedings or adjudications. So let's just look at this a little further, see if there's anything here, because he goes into the same facts that we went into in the last one. And I don't know that there's really anything more to say other than the legal standard or something here for bias. So here is the legal analysis on the bias. We skipped a few pages ahead. Judges should recuse themselves if they harbor deep-seated favoritism or antagonism as would make fair judgment impossible. Section 455B1, 28 USC, that is, 455B1, provides that a judge shall disqualify herself where she has a personal bias or prejudice concerning a party. The section is concerned with whether the court harbors an actual personal bias or prejudice against one party or in favor of another, as opposed to just the appearance of impartiality. The substantive standard for recusal is whether a reasonable person, knowing all the facts, would conclude that the court's impartiality might reasonably be questioned. A judge should be recused when her judicial predispositions go beyond what is normal and acceptable. The Supreme Court has held that the alleged bias and prejudice must, in order to be disqualifying, must stem from an extrajudicial source and result in an opinion on the merits on some basis other than what the judge has learned from his or her participation in the case. The bias and or prejudice asserted under both provisions must stem from extrajudicial sources. There's another section, 455A, any justice, judge, or magistrate shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. So then he's going to go on and argue that recusal is warranted because the judge has shown personal bias from an extrajudicial source. So the Iowa Law Review is an extrajudicial source. Okay, so that's kind of open and shut right there. A party may show the requisite bias where the court's hostility against the party's attorney is so virulent and of such magnitude that it prejudices the judge against the attorney's client. So the attorney is basically an officer of the court, as we've gone over before, very much like an officer, a police officer is an officer of the law and represents is an employee, basically an employee representing the government in for the law enforcement capacity. We are here in the judicial capacity, and as a member of a court, you are an officer of that court. If you are admitted to a court, you're an officer of that court, and that means that you are bound to follow all of your rules and oaths and everything as an officer. So, Officer French reporting for duty right here, huh? It doesn't work that way. You can't say that. And if you do, you actually kind of get in trouble for misleading people into thinking that you're some kind of other officer, because nobody knows what an officer of the court means. They know what lawyer means. So it's considered misleading if you try to trick people into thinking you have more authority than you have by calling yourself an officer of the court, even if it's technically true. Actual personal bias is demonstrated here on 3 grounds. First, judicial use of broad defamatory stereotypes. Second, there can be no serious dispute that the term troll is highly pejorative and serves no other function than to denigrate and stereotype. Third, the term copyright troll is by no means a well-settled legal term of art. So first, affixing broad stereotypes to an attorney shows actual judicial bias, he argues, and so that's his first argument. The term troll is highly pejorative in nature and demonstrates hostility against Leibowitz and his clients. He goes into the Google primary definition of troll, which is a mythical cave-dwelling being depicted in folklore as either a giant or dwarf, typically having a very ugly appearance. Goblin, hobgoblin, halfling, demon, monster, bugaboo, ogre, the storybook trolls who live under the bridge. And so obviously he's going to continue supporting the highly pejorative and defamatory nature of the word, and that the definition of copyright troll is not well settled. Judge Hellerstein used it in a Malibu Media case. That was the one that was cited above, the 2015 Iowa Law Review article by Matthew Sagg. Congratulations, Matthew, on being cited by a Richard Leibowitz case. Judge Hellerstein invoked the definition of copyright troll to address the abusive litigation practices of a particular plaintiff, Malibu Media, which is a company in the adult entertainment business targeting anonymous John Does, taking advantage of court-ordered discovery to break the veil of anonymity that separates IP addresses from the account information of actual human beings, and using the acquired information to quickly negotiate settlements on a mass scale without any intention of taking the case to trial. So he's not going to cite the Prenda Law stuff for that, I guess. The plaintiffs seemingly have no interest in actually litigating the cases, but rather simply have used the court and its subpoena powers to obtain sufficient information to shake down John Does. Malibu Media's motive is to use the federal courts only to obtain identifying information and coerce fast settlements. None of those facts identified by Judge Hellerstein apply to Richard Leibowitz, who represents world-class celebrity photographers and working-class photojournalists, virtually all of whom are living, breathing human beings who actively contribute to the progress of the useful arts. Unlike the adult entertainment plaintiffs, Leibowitz's efforts have largely been met with success in terms of judgments on the merits. He cites a number of cases, 1, 2, 3, 4, 5 cases that he got summary judgment in. There you go. Leibowitz has also helped develop a key judicial precedent in U.S. copyright law through defeating motions to dismiss. So there's 1, 2, 3, 4, 5 motions to dismiss he defeated. This is worth noting. I would definitely note this if I was in his position. Thus, the public record substantially refutes any notion that Mr. Leibowitz files lawsuits to extort settlements. Finally, he argues that Judge Kaplan's view that the sheer number of cases filed somehow justifies the troll stereotype, and he says it cannot be supported by law or logic. Magistrate Judge Peck had properly rejected a defendant's characterization of Leibowitz as a troll because, without specifics regarding the respective merits of these cases, filing volume alone does not necessarily signal an improper motivation in this counsel, let alone by Janik as the plaintiff. Impartial judicial officers are to adjudicate matters based on the individual parties and facts presented on a case case-by-case basis. Here, Judge Kaplan's invocation of the troll stereotype to defame Mr. Leibowitz without any justification, save for the number of cases filed, failed to consider whether Mr. Leibowitz's clients are authors and whether the defendant in those cases actually violated federal law. By relying on broad-sweeping stereotypes and defamatory labels to justify its extraordinarily adverse rulings, the court has revealed a deep-seated personal bias against Leibowitz that renders a fair and impartial ruling on the case impossible. And as explained below, recusal is warranted. The problem with his using the phrase copyright troll to label Mr. Leibowitz is that such stereotype is automatically imputed to every client he represents, who are the actual owners and authors of the copyrighted works. By labeling Mr. Leibowitz a copyright troll in this proceeding, the court has not only reinforced its own personal animus against Leibowitz, but it has also revealed hostility towards Mr. Sands himself as the owner of the photograph in question. If Mr. Leibowitz is a troll, according to Judge Kaplan, then it must follow that Sands is also a troll. Indeed, the narrative conveyed by the court is that Mr. Sands has no right to be enforcing his copyrights against Bauer because Sands' copyright is of modest economic value. Given the court's use of this prejudicial label, a reasonable person informed of the facts would perceive a significant risk that the court will resolve this case on a basis other than the merits, which is exactly what has happened. So he continues to argue the recusal facts and then concludes with his request for recusal. And that was just on October 29th, so we will see what happens. That was 2 days ago. So what do you think? Do you think Richard Leibowitz made a good point there, that even if what he's doing is troll-y, maybe the judges shouldn't call him that in court because it shows bias? And if the judges are biased against his clients because Mr. Leibowitz files a lot of cases, that's actually quite incorrect. I agree with Leibowitz on that one. He should lose on the merits or win on the merits, and if he makes mistakes, he should suffer the natural consequences of his mistakes, being held for sanctions, for monetary sanctions, being disbarred in the one case. So he should be held to account for that. But to be then blanket labeled a troll because the judge doesn't like that his plaintiffs are enforcing their rights, that seems an overstep by the court. So I think I agree with Richard Leibowitz on this one. If nothing else, at least the judge has to. Well, I think he said he can't. The judge has already ruled, so I don't think there can be an undoing of this unless it goes through this vehicle of recusal and all that. So interesting arguments made by Leibowitz. I kind of like the guy. I don't like his potential violations of Rule 1.1, but I kind of like the way he argued here. I can see why his clients might hire him, because he seems to be good with the argument there. Let me know your thoughts in the comments below. Thanks for watching. I am Leonard French, your favorite copyright attorney. That is our show. Thank you to our sponsors in the month of October. Remember, this is a show that was produced at the end of October, on October 31st, so that there will be a slight rollover. Supporters who support in November will get charged on November 1st, and will also roll over into the very first days, 1 or 2 days of December. So thank you to our October sponsor, channel sponsor, Joshua Davis from TandaPay. Thank you very much for all of your support. Thank you to our October $50 plus supporters, Joe Tyson, Aspernari, John Steele, Gavin Barnard, Evie, Kyle Mudrock, Michael Pierce, Spirit Bear, Jan Negre, Daniel Perez, Snorri Wizatsky, Black Leaf, and Benjamin Hightoff. And thank you to the $5 plus supporters who are scrolling on the screen in front of me, and all of you are on the LED panel behind me. I'm Leonard French, your favorite copyright attorney. I look forward to seeing you in the videos that drop. I will see you on Sunday for the 10 a.m. show at the U.S. time. I love you all. Bye. Did you get a bath? Are you the golden retriever that got a bath? Daddy's not paying attention to you? Daddy's not paying attention to you. Yes, and you're out of focus too, because we don't have autofocus on this. Hello, my boy. Hello. Let me say hi to my boy. Hang on. Let me put the camera down. We'll point it at you. Hang on. Whoa. And Ilsa's just gonna wreck it. Good job, Ilsa. Good job, Ilsa. Let me say hi to my boy. Hello, my boy. Hello, my boy. Hello, my dogs. Hello, my dogs. Hello, my dogs. Hello, are you happy to see me? It's been a day or two, huh? Have I been taking care of things? Have I been taking care of things? Huh? Are you my good boy? Like the good distracted boy? He just loves to be hugged. Loves to be hugged and cuddled. Huh? 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 My boy. This is my dog. This is my dog. There are many like it, but this one is mine. Oh, let's see what we can capture with you with the camera here.